our new developments in the death penalty case against the Tops mass shooter. The judge presiding over the case says lawyers representing Peyton Gendron will be allowed to see some personally identifiable information about potential jurors for the federal trial later this year. Joining us now to provide his expert insight on all this is former U.S. Attorney Joel Violanti. All right, Joel, thank you for the time. As always, you looked over the judge's decision on this, Judge Villardo's. Did anything stick out to you?
No, it's not unusual to have certain information turned over to defense in cases like this when there's cause being shown. You have to understand, normally jurors are picked and selected just before the trial happens. So the information is disseminated in court as they're asking questions. In this particular case, it's my understanding there has been jury questionnaires given to potential jurors quite a while ago. And that information came to the courts and the parties, and they're able to digest that. The defense, according to the order that I saw today, had hired an expert to help them out and assist with trying to pick the most fair juror for the defendant. And they felt that there wasn't enough information available to them, that they wanted more, that their expert needed more to make a determination and help them put on a valid defense. The government obviously opposed that because it's usually the utmost important to keep juror personal information private, because you don't want it to get out there, especially in today's day and age with the internet and everything else. The last thing you want to do is have jurors' information, names, addresses, date of births, all that out there, because for the obvious reasons, you don't want anybody to be intimidated, contacted, or swayed one way or the other. So it's very important for the court to balance that. What's the need here? And the court did, and Judge Villardo is probably one of the most fair judges I ever practiced in front of, took all that information, decided that no, we're going to allow that information to be disseminated to defense, but only under certain restrictions, only to the defense attorneys and the expert, so that the expert can review that, look at that, take that information into account, and help the defense formulate a selection process that they think is going to be fair to their client. It should be noted, I think the information, as I read from the order, like they could give name, addresses, voter ID, license numbers, driver license, jury IDs. A lot of this information is given in court during the normal jury process. But it looks like here the defense wanted some of that early on, ahead of time, so they could use their expert and decide who's going to be the best juror for their case. And remember, I think I started off saying it's not unusual. It's really not in these type of cases, because this is a death penalty case, and they have an individual whose life's on the line, and ultimate penalty could be death. So the judge, as he did in this case, is going to balance the interest, the privacy interest of the potential jurors compared to the need for the defense to put on a fair defense, and have the due process it deserves. So I think the information, the way the judge carved out the order, saying that this information can be presented to the defense and their attorneys only. It did not mention the defendant, and it looks like that the defense attorneys who are assigned to represent the defendant and the expert can look at that information without it going to the defendant. And I think the judge felt comfortable, especially with the order saying it cannot be disseminated to anybody else subject to contempt or other type of sanctions by the court. I think the court in this particular instance felt that it was fair that the privacy interest of the jurors were outweighed by the need of defense under these circumstances as they're being protected by the court order.
All right, Joel, of course, a lot of information here to digest, but can you look ahead now to the summer months when jury selection is expected to start? And how do you think things will go given all the legal motions up until this point?
Well, they have the best prosecution team. I tried case against this defense team. I tried cases from this judge, and I can tell you that they have the best there. And there's not going to be one issue that's not going to go probably not contested and not given the utmost attention by all parties. But the process, we're going to have to wait and see, because like I said from the outset, the jury selection process, the questionnaires, that's not utilized in every case. As I said, the jury selection process usually starts just before the start of trial. So the defense attorneys have this information, and a lot of the selection process may not be happening in the court like it normally does. It may be happening with the court prior to the court in the effort to speed this along, because I anticipate that many questionnaires went out to many jurors, and they're probably questioning a lot more jurors than they normally would, given the fact that this is a death penalty case. So you may not be seeing it questioned in the courtroom as much as you usually do, the jurors, because a lot of that may have happened beforehand. But I'm not sure what approach the court is going to take in this instance, so we'll just have to wait and see.
All right, former U.S. Attorney Joel Violanti on the latest on the federal case against the top mass shooter. Thank you for the time.
Thank you.
All right, and you can find the latest details on Judge Lawrence Velardo's decision, along with our continuing coverage of the case against Peyton Gendron on our website, WIVB.com.